Hello. The meeting of the Committee of the Whole is hereby resumed. Floor leader.
May we now
Floor leader.
no mic.
Meron na. You already have.
May we now recognize Dr. Ano? I move that we resume consideration of House of RHB number 7, Speaker, and that the Secretary General be directed to read the title of the measure.
Secretary General is hereby directed to read the title measure.
A resolution of both houses of Congress proposing amendments to certain economic provisions of the 1987 Constitution of the Republic of the Philippines, particularly on Articles 12, 14, and 16.
Floor leader.
Mr. Chairman, I move that we recognize Dr. Philip Arnold P. Tuanyo, Dean, Ateneo School of Government of the Ateneo de Manila University.
Dr. Philip Arnold P. Tuanyo, Dean of the Ateneo School of Government, Ateneo de Manila University. You have the floor.
Mr. Speaker and honorable members of the House of Representatives, good afternoon. Let me just reiterate before I give my testimony that the statement does not reflect the views of the Ateneo de Manila University, but represent personal views of some of its faculty. We live in a different world from when our Constitution was crafted over 40 years ago. Roughly 70% of our population was not even born yet when this Constitution was crafted. Much has changed since then. The Philippines is different, and we know that the world is different. The world just survived a devastating pandemic only to usher a period of geopolitical risks. Rapid advancement in artificial intelligence, or AI, and automation formed the spearhead of the Fourth Industrial Revolution, which offers both opportunities to those countries that can adapt and reskill, as well as deep political challenges due to inequality that it will likely exacerbate. The Philippines, as we know, is no longer the sick man of Asia. The World Bank projects the Philippines is set to achieve upper middle income country status by 2025. And our economy is set to hit the $1 trillion mark by 2033. At the same time, the proportion of households who are so-called middle class, at least by income in international standards, in the country has grown. And yet our growth has been uneven and unequal. More households are vulnerable to economic, health, and natural resource shocks. And millions of Filipinos still seek greener pastures abroad, despite many political promises to produce enough jobs to start bringing them home. Our Philippine Development Plan 2023-2028 emphasizes servicification as part of our industrial policy strategy to leverage our strong comparative advantage in services in order to boost other sectors, such as manufacturing. The latest thought leadership on modern manufacturing is that we can no longer hope for the same era of manufacturing-led growth of the past, given since we live under a new wave of industrialization under the Fourth Industrial Revolution. Automation, Internet of Things, AI, and the knowledge-based economics is already reshaping the world, and further the geopolitics of the times will offer both challenges and opportunities for the Philippines. Harvard professor Danny Roderick, in his 2022 keynote address to the Philippine Economic Society, noted that the era of so-called hyperglobalization of the 1990s had ended because of geopolitical realities and the pressures of premature industrialization, or that many developing countries are running out of industrialization opportunities sooner and at much lower levels of income because of the domination of the world market by advanced countries. We cannot be left further behind by our neighbors, and so discussions to unleash our services sectors are needed to compete more fully. advancing evidence-based discussions on how to strengthen key economic sectors by attracting not just capital, but also critically technology and know-how is key to our continued economic development. While we have managed some degree of economic openness, many sectors remain relatively restrictive, which limits our options and pathways to promote and sustain inclusive economic development. In the same presentation, Professor Roddick suggested a focus on so-called middle productivity sectors, sectors whose potential and competitiveness can be dramatically enhanced by reasonable investments in technology. Perhaps the applications that enhance the competitiveness of small and medium enterprises or information access to enhance tourism and transport services come to mind as examples in our country. Technology can also be leveraged to underpin a resurgence in manufacturing, notably with the advent of advanced intelligence and Internet of Things. The industrial Internet of Things could help transform more traditional manufacturing facilities and processes into smart spaces. This Internet of Things in manufacturing could help enhance factory safety and productivity, benefiting frontline workers, and it could also enhance productivity and efficiency, in turn providing the means to provide compensation and contribute to living standards. The creative sectors with modern engineering and R&D could also help enhance manufacturing, ensuring that services-infused manufacturing is competitiveness and responsive to consumer trends and more specific needs by the market. More broadly, Professor Roddick argues that technologies that complement and augment what workers can do, expand the range of tasks that they perform, increase their ability to customize services to specific needs and customer demand, and increase the labor share value added into production. There are many examples of this where this is already in progress. Rockwell Collins Aerospace, an American nautics team, which in 2017 in the Philippines acquired another American firm, BE Aerospace, which manufactures aircraft galleys, ovens, and lavatories in Tanawan, Batangas several years ago, agreed to provide high-value services to enhance the manufacture of parts of Boeing 737 and Boeing 787, the most in-demand passenger airliners today. The kind of servicification of manufacturing is not new and can be made to work in favor to attain more complex production patterns that produce high-quality, good-paying jobs. But for all this, we need the skills to build up to successfully compete in this way. This is where the economic charter change comes in. Our education and media sectors are still restricted, so the full synergies of competitiveness are not yet fully unleashed. Unlike our ASEAN neighbors, Singapore, Malaysia, Vietnam, Thailand, Myanmar, Laos, Cambodia, which all permit full foreign ownership of education institutions, we are still relatively close. Hence, our connections to foreign know-how and technology are also constrained, and hence our aspirations to build a knowledge economy are also constrained. Foreign institutions, education institutions can also be a source of additional employment as well. In Malaysia, for example, the country attracts students from throughout the Southeast Asian region, as a well-known host for transnational higher education, having branches of 8 foreign universities, mainly from the UK and Australia. DTI recently launched its manufacturing campaign to launch manufacturing renaissance in our country that leverages our core strength in services. They are responding to the landscape as what Professor Roddick described it. We cannot hope for the same old low-cost manufacturing model in this new world. We were never low-cost anyway, so might as well we may be high-skilled and cultural, creative, and tech-savvy. Several attempts have already been made by reform governments in various post-EDS administrations to advance economic charter change, to continue to expand the scope and ambition of our economic development. As we also heard earlier, there is considerable evidence that loosening restrictive economic provisions in the Constitution can form a part of broader reform to boost foreign investments and create jobs for Filipinos, so that many do not need to leave for greener pastures abroad. That reform agenda must also include reforms to boost independent regulatory agencies, also in our education sector, and strengthen social protection for those that may be affected by increased openness. We must improve the inclusiveness of our market economy so that we do not fear economic openness, and instead see this as a strategic way to provide jobs for our youth, bring back home our millions of OFWs. It is also a key component of bolstering our national security, since socioeconomic development goes in hand with a strong national defense. Our biggest challenge on each attempt is the deep distrust in our political system and our ability to conduct industrial policy fairly, transparently, and successfully. At the end of the day, if and when we do open up the competition, our institutions, even our governance, need to also level up so we don't end up on the losing side. We must overcome this in order to strengthen our chances to compete successfully. Thank you very much, Mr. Speaker.
Thank you very much. Dr. Philip Arnold Tuanyo, Dean, Ateneo School of Government. Floor Leader.
Mr. Chairman, I now move that we recognize the Honorable Justice Renato Espuno, retired Chief Justice and Chairman of the Philippine Constitution Association.
Thank you,
The
and
Chair would like to recognize retired Chief Justice Renato Espuno. You have the floor.
thank you, and good afternoon, Your Honors. In the interest of time, let me go directly to the constitutional issues involved in Resolution Number 7, entitled A Resolution of Both Houses of Congress proposing amendments to certain economic provisions of the 1987 Constitution of the Republic of the Philippines, particularly on Articles 12, 14, and 16. The resolutory part of the joint resolution reads as follows. Resolved by the Congress, upon the vote of 3/4 of all its members, pursuant to Article 17 of the Constitution, to propose amendments to Articles 12, 14, and 16 of the 1987 Constitution, etc. What does Article 17 of the Constitution provide? It provides as follows. Section 1. Any amendment to or revision of this Constitution may be proposed by 1. The Congress upon a vote of 3/4 of all its members, or 2. A constitutional convention. The meaning and proper interpretation of Article 17, Section 1(1), which read, the Congress, upon a vote of 3/4 of all its members, has been the continuing subject of debates between and among law and non-law experts, and between the members of the two houses of Congress. And to date, this issue has been unresolved. Until this constitutional issue is settled, all these talks about amending certain alleged restricted economic provisions in the Constitution may just be precipitate. How did this constitutional confusion happen? It is a case of unfortunate inadvertence, a case of unfortunate inadvertence on the part of the framers of the 1987 Constitution. According to the views of former Chief Justice Hilario Davide Jr., former Associate Justice Adolf Ascuna, and Christian Monsod. Initially, they said the committee in charge of amendments thought that a unicameral Congress would be adopted. Contrary to their expectations, however, the framers adopted in the last minute a bicameral Congress. And in the rush of things, they forgot to adjust their recommendation on how to amend the Constitution in the case where Congress is bicameral and meeting as a constituent assembly. Hence, we have this so-called anomaly. Article 17, Section 1(1) saying any amendment to or revision of this Constitution may be proposed by the Congress upon a vote of 3/4 of all its members, which is fit and proper for a unicameral Congress, but not for a bicameral Congress. This unfortunate inadvertence gave birth to two opposite schools of thought on how Congress, when convened as a constituent assembly, should meet and vote. That is, whether they should meet and vote jointly or separately. The first school of thought maintains that provision in the Constitution is an admitted case of inadvertence. Hence, it should be interpreted in light of the fact that we have a bicameral Congress, and we should not stray from the tradition and the practice that when their members convene as a constituent assembly, they must meet jointly and vote separately. On the other hand, there is a second school of thought. The second school of thought is espoused by Father Joaquin Bernas, himself one of the framers of the 1987 Constitution. Father Bernas posits the theory that Article 17, Section 1(1) of the Constitution merely grants Congress the power to act as a constituent assembly to amend or revise the Constitution. Let me repeat the theory of Father Bernas. His theory is that Article 17, Section 1(1) of the Constitution merely grants Congress the power to act as a constituent assembly to amend or revise the Constitution. He then submits that how the two houses shall meet, how they shall vote, whether jointly or separately, is up for the senators and the congressmen to determine by the rules that they will adopt. That is the view of Father Bernas. And so, this is our constitutional quandary, Your Honors. How to interpret this Article 17, Section 1(1) in a manner that is aligned with the intent of its framers and in accord with the will of the people when they ratified the 1987 Constitution. My impression, Your Honors, is that by and large, both houses, the Senate and the House, are adopting the Bernas interpretation of Article 17, Section 1(1). Although there remains the divisive issue of whether the two houses will vote jointly or separately. With due respect, Your Honors, you can expect a constitutional challenge with the adoption of the Bernas model and interpretation. I'm not passing judgment on the merits or the demerits of the Bernas model. I'm discussing this only in the interest of a more informative, more enlightened discussion. And let me cite just two reasons why the Bernas interpretation will be subjected to a constitutional challenge. One, the view of Father Bernas is a personal view. That view of Father Bernas was never ventilated, never discussed when the framers of the 1987 Constitution deliberated on Article 17, Section 1(1). Father Bernas floated that personal view long after the 1987 Constitution has been ratified by the people. He floated that personal view only when he wrote his commentaries on the 1987 Constitution. In construing or in interpreting the Constitution, personal views do not carry much weight, precisely because they are personal views and do not reflect the consensus arrived at by the framers of the Constitution. Secondly, Your Honors, the facts established, the uncontroverted facts, show that this Article 17, Section 1.1, is there by inadvertence, by inattention, when the framers adopted a bicameral Congress instead of a unicameral Congress. In other words, Your Honors, there is nothing in the proceedings of the Constitutional Commission that will contravene the intent to adopt the traditional way of meeting, the traditional way of voting when Congress is convened as a constituent assembly. And that is meeting jointly and voting separately. The traditional way, the classic way, is expressed in Article 6, Section 1 of the 1935 Constitution, which states, the Congress in joint session assembled by a vote of 3/4 of all the members of the Senate and of the House of Representatives voting separately may propose amendments to this Constitution. That is the classic formulation, the traditional formulation, when a bicameral Congress meets as a constituent assembly in order to amend or revise the Constitution. Again, Your Honors, in interpreting the Constitution, one of the hallowed principles is always to know the intent of the framers. And knowing that intent, to enforce and implement that intent. This hallowed principle of constitutional construction may be violated if we disregard the reality that Article 17, Section 1 of the Constitution is there by inadvertence, is there by accident, is there as a clear error, for it is intended for a unicameral and not for a bicameral Congress. The question, Your Honor, is there a way out to settle this issue? This issue that cannot be settled by the legal experts. This issue that cannot be settled by both the houses of Congress. Under our Constitution, Your Honors, and this is my humble submission, there are two ways to settle this problem. The first way is the political way. The political way is to submit this issue to the people for their judgment, either in an obligatory or a non-obligatory referendum. Let the people speak on their intent when they approve this Article 17, Section 11 of the Constitution. Is there intent for the two houses to meet jointly and vote separately? Or did they discard the traditional understanding when they approved this Article 17, Section 11 of the Constitution? It can be argued that if the people speak on this issue, whatever is their judgment cannot be reviewed by the Supreme Court, because it constitutes a political question which is beyond the jurisdiction, beyond the competence of the Supreme Court. The second way, Your Honors, is the judicial way. This issue can be brought for interpretation by the Supreme Court. Needless to state, the requirements of review by the Supreme Court should all be complied with. The requirement of ripeness of the issue, the requirement of standing of the parties, the showing of grave abuse of power. If all these requirements can be complied with, I am confident that the Supreme Court will settle the issue in the exercise of its power to interpret the Constitution. Let us remember that the 87 Constitution expanded the judicial powers of the Supreme Court. Article 8, Section 1 of the 87 Constitution expanded and redefined the perimeters and parameters of judicial power. It now reads as follows: judicial power includes the duty of the courts of justice to determine whether or not there has been a grave abuse of discretion amounting to lack or excess of jurisdiction on the part of any branch or instrumentality of the government. Your Honors, that phrase, grave abuse of discretion, is broad enough to allow the Supreme Court to settle this dispute. In other words, to make a proper interpretation of Article 17, Section 1 of the Constitution in an appropriate case. Your Honors, I wish I have more time to discuss my second point on why the procedure provided in liberalizing Articles 12, 14, and 16 of the Constitution may be, again I stress the word, may be constitutionally suspect. But let me just submit this short point in the interest of time. That the use of the phrase, unless otherwise provided by law, is vulnerable to another constitutional challenge. Number one, Your Honors, allowing Congress to use its law-making powers to amend the Constitution may be questionable. Number two, the laws that will be passed by Congress for this purpose will not be approved by the people in a proper referendum. Under all our constitutions, 1935 Constitution, 1973 Constitution, and especially under the 1987 Constitution, any and all changes in the Constitution, whether they come from a constitutional convention, whether they come from a constituent assembly, or whether they come from a people's initiative, have to be approved by the people in what is known as an obligatory referendum. That approval by the people cannot be set aside, cannot be short-circuited. So, again, these are some of the constitutional problems. But again, what is the way out? My respectful submission, Your Honors, is just to do away with this phrase, unless otherwise provided by law. Just repeal these three restrictive provisions of the Constitution, which you want to be out. And in addition, you just repeal Article 2, Section 19 of the 1987 Constitution, which states, the state shall develop a self-reliant and independent national economy effectively controlled by Filipinos. Include that in the repeal. If all those provisions will be repealed, then Congress, in the exercise of its law-making power, can enact all the necessary laws in order to attract these foreign investments. By the repeal of all those provisions, you let go the power, the lawmaking power of Congress. That is, to me, how simple it is. Thank you, Your Honors. I have no time to really expand more on these submissions. And if I may be allowed, I will submit to this House a more expanded version of my position. Thank you, Your Honors.
Thank you very much, the Honorable Chief former Chief Justice Renato S. Puno, the chairman of the Philippine Constitution Association, PhilConsa. Floor leader.
Mr. Chairman, first to ask questions from our resource person is the Honorable Minority Leader, the Honorable Nonoy Libanan. I therefore move, Mr. Chair, that he be recognized.
The Honorable Minority Leader, you have the floor. Please proceed.
Thank you, Mr. Chairman. Mr. Chairman, I understand nasa general provisions pa lang tayo at hindi pa sa specifics. Kaya itong pagtatanong ko ay hindi ko alam kung sinong sasagot nito kasi walang nakatayong...
Mr. Chairman,
Floor leader.
Mr. Chairman, my apologies to the Honorable Minority Leader and my apologies to our last and very important resource person. If I may, Mr. Chair, may I request that the Honorable Minority Leader defer his interpellation. And with that, Mr. Chair, I move that we recognize the Honorable Attorney Alfredo Pido Gabin Jr., the Executive Director of ACO Bicol Party List.
Thank you, Majority Leader.
The Executive Director of ACO Bicol Party List, Attorney Alfredo A. Garbin Jr. You have the floor.
Thank you and good afternoon, Majority Leader, esteemed members of this 19th Congress, fellow resource person, invited guests. Magandang hapon po sa inyong lahat. And I'm so happy and humbled to join this discussion in a matter that is very important, being close to my heart as former chair of the Committee on Constitutional Amendments in the 18th Congress. The Constitution is an organic law of the Republic of the Philippines, should be living and a breathing organism, such that it should change and be able to adapt to the advancement and progress of our nation. In fact, the framers of the Constitution deem it fit to include Article 17 to dictate how the changes can be effected. The present iteration of the Constitution has been in effect for over 37 years already. While it provided political and economic stability for the growth of the nation, for the said period of time, there's a strong and impending need for a change so that our country will be better equipped to keep up with the global changes. Note that the provisions of the present Constitution has been adopted and carried over from the 1935 to 1973 iterations of the Philippine Constitution. It does not take into consideration the current economic, business, and financial landscape brought about by globalization. In this exercise of the sovereign and original power to amend the Constitution, the people expressed their clear and unequivocal intent to delegate the power to amend or revise the Constitution to Congress as one body, perhaps voting jointly or separately. No one house should be allowed to frustrate the efforts of the other and effectively paralyze the entire Congress from discharging its powers as a constituent assembly to revise or amend our fundamental law to promote the general welfare of the Filipino people. Voting jointly will not dilute the powers of the two houses because each member of Congress, whether a senator or a member of the House of Representatives, pursuant to the democratic system of government, is entitled to one vote and shall be afforded that vote as a manifestation of the equal representation of the people's will. Regardless of the size or influence of a particular house, the power emanating from the people is distributed individually to each member of Congress, ensuring that every voice contributes to the collective decision-making process. Voting jointly does not diminish the significance or authority of either house, but rather reflects the intention to combine the perspective and mandates of both houses to reach a comprehensive and representative decision. This parity of voting is a distillation of democratic representation in its purest form, meaning one person, one vote. It hails from the original power of the people who enacted the Constitution, who can thus rightfully amend the same through their elected representatives in the manner they see fit. The late Justice Isagani Cruz, in interpreting Article 17, Section 1 of the 1987 Constitution, argues for a joint session and a joint vote. He said, whenever any vote is of all members without further classification or qualification, this should be a vote based on total membership. On the other hand, I would also like to bring to the minds of the Filipino people that if allowed, this is not the first time that the House of Representatives and the Senate vote jointly. This manner of voting is not an anomaly or a new concept in the Constitution. Article 7, Section 18 of our Constitution prescribes that joint voting of the two houses in matters which are considered to be of supreme and paramount importance. These are two instances. Number one, when revoking or extending the proclamation of writ of habeas corpus, and when revoking or extending the declaration of martial law. A careful scrutiny of the Constitution reveals that the system of check and balances will not be altered by this manner of voting when it comes to amendments or revising the Constitution. The system is set by the Constitution itself when it imposes that a plebiscite should be held for a particular purpose of introducing changes, where the majority votes cast will decide the fate of the proposal. This was not changed or even touched upon by the proposed amendment. The question is now, who has the better and moral constitutional authority to perform the check and balances than the sovereign Filipino themselves? So let the people decide. Thank you, Mr. Speaker.
Okay. Thank you very much, Attorney Alfredo A. Garbin Jr., Executive Director, Ako Bicol Party List. Floor Leader.
Mr. Chairman, I move for a few minutes suspension.
Hearing is resumed.
We will now proceed with the interpellation by members who have registered to interpellate. And of course, the first to interpellate will be the distinguished minority leader, the Honorable Nonoy Libanan. May we just request whoever will be the interpellator, if they know, can specifically refer to the particular person to whom the question will be directed. And may we also request the resource people here, if they want to answer the question, they can just give us, they can just raise their hand so that we will be able to call upon them to answer the question to be propounded by any of the members. So for this purpose, Mr. Speaker, may we recognize the distinguished minority leader for his interpellation.
The Honorable Minority Leader Nonoy Libanan, you have the floor.
Thank you, Mr. Chairman. Thank you, Mr. Majority Leader. I would like to ask this question to NEDA. Is the Secretary Balisacan around? Still around? Or his representative?
Or any representative from NEDA.
Thank you, Mr. Chairman. I would like to ask, is this an opportune time to amend the 1987 Constitution, even if limited only to 3 provisions to be amended through the RBH 7? In other words, Mr. Chairman, nasa tamang panahon po ba tayo?
Mr. Chair?
Yes, please state your name before replying to the interpellator.
Yeah, Undersecretary Rosemary De Leon from the NEDA.
Okay, you may respond, Undersecretary Rosemary Edilion.
Yes, thank you, Mr. Chair. So, NEDA supports the amendment of the economic provisions of the 1987 Constitution. So on the question on whether it is an opportune time, we actually think so, especially because we do not, we want to really be able to respond to shocks that we know will be coming our way very soon. It will be a very volatile, uncertain, complex, and ambiguous world. For instance, taking off from the Ibon slide on the economic restrictiveness, on the foreign equity restrictions, we noted there that with respect to, let's say, the telcos, with respect to the telcos, that we are already more open than the other ASEAN countries. But actually, that is the situation now. If you would recall, the situation before the pandemic was not like that, and that is the reason why we were actually more restrictive than the other ASEAN countries. And so when the pandemic struck, we were unable to adapt quickly to the changes that we needed to undertake in order to be able to not have all those very restrictive mobility regulations, Mr. Chair. Thank you.
Thank you, Mr. Chairman.
Yeah, Minority Leader, please proceed.
If I may ask our former Chief Justice for his opinion, Mr. Chairman. It is said that the original proposal to the 1987 Constitutional Commission was for the Philippines to adopt a unicameral legislature. But this was, however, not accepted by just one vote. When the Constitution was redrafted to conform to the bicameral legislature, however, one provision was overlooked, the provision on how Congress may propose a constitutional amendment or revision. Paragraph 1, Section 1, Article 17 does not specify if Congress should meet in joint or separate sessions and or vote jointly or separately. What is your thoughts on this statement, Chief Justice?
Yes, Your Honor. I precisely discuss the two warring schools of thought that developed because of that provision, which is fit and proper for a unicameral Congress, but not for a bicameral Congress. That's why they said it's a case of inadvertence, because the framers failed to change that manner of amendment when the Constitutional Commission in the last minute adopted a bicameral Congress and not a unicameral Congress. Because of that provision, you now have the school of thought championed by Father Bernas, and the other contending school of thought saying that that is a provision there in the Constitution by inadvertence, and therefore should not be followed because it does not express the intent of the framers, nor does it express the intent of the people that adopted that provision. That is our quandary, how to properly interpret that provision, which by history is thereby inadvertence.
Minority Leader.
Thank you, Mr. Chairman, for that. Ito pala yung cause kung bakit napakahirap ma-amend ang Constitution natin for 36 years. Wala pa tayong nabago sa Constitution. Nandito pala yung choke point, yung papaano natin ma-amenda po ito. Now, Mr. Chairman, I would like to ask former Congressman Attorney Pido Garbin for his thoughts on some issues on this. It is said that the original, or by of itself, RBH 7 does not really amend the Constitution. Rather, it permits Congress to amend specific constitutional provisions by enacting appropriate laws. Is that not correct? Tama po ba?
The proposal makes the restrictive provisions flexible, but it is imposed with a condition, meaning unless otherwise provided by law, you need an act of Congress to provide specifically whether to make the foreign equity 100% or make it 50% or totally remove the foreign equity limitations in the Constitution. But by proposing an amendment with an unless otherwise provided by law, you only make the provision flexible. It does not make an automatic amendment to the Constitution.
Minority Leader.
Mr. Chairman, it is my understanding that RBH 7 of this, then the laws that may be enacted by Congress to alter the ownership, restriction of public utilities, educational institutions, and advertising firms will pass through the legislative process. Specifically, such laws will need to go through public hearings and plenary debates. Is this correct? Mr. Chairman.
Minority Leader, to whom are you directing the...
To Attorney Garbin, please.
Yes.
Can you
Attorney
please
Garbin.
repeat the question, please?
May I repeat? If RB 7 is correct, Mr. Chairman, then the laws that may be enacted by Congress to alter the ownership, restrictions on public utilities, educational institutions, and advertising firms will pass through the legislative process. Specifically, such laws will need to go through public hearings, plenary debates, and the things we do in legislation. Is this correct, Mr. Chairman?
That is correct, Mr. Chairman.
And if we approve this, this will not go through after, for example, we submit this or forward this to the Senate, and if we have BICAM, this will not go to the President, but this will go to the COMELEC, so that a plebiscite can be conducted for this purpose, if approved. Is that correct, Mr. Chairman?
Well, we have different views to that, but in my view, it will no longer undergo the required referendum because that provision was already relaxed by inserting the phrase unless otherwise provided by law. Meaning, it will go through the ordinary course of legislation. The House propose, the Senate provide their own counterpart, and then if they agreed on the provisions of the proposed legislation, then it will be submitted to the office of the President. But Chief Justice Puno has a different view on it.
Mr. Chairman, if,
Minority Leader.
kung pwede po, sino bang ang nasa Department of Justice po dito na pwedeng maging resource speaker? Kung ano ang stand ng ating Department of Justice, kasi yun po ang official na council ng ating pamahalaan. Saan po ba ito patungo? Sa Office of the President or sa taong bayan in a plebiscite?
Mr. Chairman,
Floor Leader.
we actually don't have a resource person from the Department of Justice, but if the Honorable Minority Leader will agree, since we're dealing with proposed economic provisions, maybe Attorney Agaton Teodoro Overo of the DTI, who has also held various government posts before, and Mr. Romeo Bernardo of the BSP can answer his questions.
Mr. Chairman, sa tingin ko po magkakaroon ng iba't ibang interpretation po dito. Ang pinakamaganda po dito, anong official stand ng ating pamahalaan? Kung legislative process ba ito na aprubahan ng both houses, then it goes to the President for approval, or nagkaroon tayo ng BICAM, pagkatapos po ng BICAM, isusubmit natin sa COMELEC, then we ask our people. Dalawang magkaibang ruta po ito.
Mr. Chairman,
At ngayon pa lang dapat alam na natin kung saan tayo
I
patungo.
may just inquire from
Floor Leader.
the Minority Leader if the question is directed on what's going to happen if we approve RBH 7.
7.
Will it go to the Office of the President? Is that what you're asking?
Yun po ang aking itinatanong.
Well,
Kasi una, pag naprubahan po natin ito, it will go to the Senate.
Yeah.
Po ba?
That's correct.
Ngayon, kung magkaiba ang version natin, dahil so magkakaroon tayo ng bicameral conference committee
Yeah.
meeting to reconcile both versions.
Yes.
After that, anong gagawin natin? Ipapaprove natin siguro
Yeah, of course.
jointly or separately, di ba?
But by this time, the distinguished Minority Leader, I'm sure, is well aware that we have just mimicked what is filed in the Senate. Meaning, we did not add or we did not deviate from what is pending in the Senate. It's exactly the reproduction. The hope is ako ho, ito lang naman ho ang akin. Nabasa ko ho kasi kaninang umaga sa isang pahayagan. Whether totoo o hindi, ayoko ho pangunahan ng mga senador. Pero nabasa ko po ay the senators promised the President na aaprubahan nila. What is pending before them? Yung RBH 6 yata, no? RBH 6. Before we declare a London break. Before we declare it, we will be declaring a London break sometime between March 18 to 21 or 22. So, whether totoo yun o hindi, I do not know. Basta sinabi lang na. Assuming that to be true. Assuming that to be true. Ano ngayon ang ginawa ng House? Final lang natin what is exactly pending before the Senate in the hope that expediting the proceeding. Instead of us waiting for the Senate na aprobahan nila yon, batalan nila rito, and then saka na lang natin take up. Because nothing prevents us from filing a similar or exactly the same resolution. So what's going to happen? Kung halimbawa, we approve our RB 87 by the required vote as provided for by the Constitution. And let us say by stroke of luck, the Senate likewise did the same. Walang pagkakaiba. Then, ang submission ko, it does not have to pass to the office of the President because this is not a bill. This is a concurrent resolution of both houses. So, kung pareho yan, referring to the same and exact thing, which is amending the specific provision of the Constitution, then all we have to do is parang in the nature of an enrolled bill, send it to the COMELEC. For the COMELEC to schedule it for a plebiscite as mandated also by the Constitution. Now, if it so happens, let us say, tayo naman dito sa House, if we fail to have a vote, kahit na isa lang, kulang, to manage the 3/4 vote, then patay na yung bill. There's nothing to send to the Senate. Wala na tayo papadala yan. Kung magkaiba ang version natin, and hopefully hindi nga magkaiba, dahil kung ano yung final nila, yun yung final natin, yun ang gusto natin na minirror lang natin, ang hope natin, ma-expedite, na pareho tayo, hindi na kailangan tayo mag-BICAM. But on the assumption na magkakaiba ng konti, then nothing prevents us from calling a BICAM. But this time around, pag pinabalik na, assuming na mag-reconcile yung dalawa na yan, hindi na katulad ng ordinary BICAM that it can be adopted by a mere ayes and nays vote. Because we have to comply then sa 3/4 vote of all the members of the House, kahit na bicameral conference committee. Otherwise, should we shortcut it na inapprove natin ng 3/4 vote of all the members yung reso, and then pagdating ng BICAM, pwede palang ayes and nays lang, then that defeats, and I myself will say that will be in violation of the Constitution.
Mr. Chairman, kaya nga yun po ang gusto kong i-clarify ng representation na ito. Dahil ang sabi po ng ating resource person na iba yung view niya na pag na-approve natin after BICAM, papunta na sa Presidente para ma-approvehan. Ngayon, maliwanag na po yung sagot ng ating majority leader, and I believe it is the stand of the majority na this will go to the people in a plebiscite because after all, sovereignty resides in the people. Kaya specific po itong provision ng amendment na
When
papunta
Congress
sa taong bayan.
exercise its consequent power, hindi kasama Office of the President dito. Basta nagka-agree lang and we have voted either separately or whatever, basta yung requisite number of votes, 3/4 of all the members, hindi kailangan padala sa Office of the President to, unlike an ordinary bill or a joint resolution. Because this is not an ordinary bill or a joint resolution, hindi nga be enacted ito resolve because we are resolving, both houses of Congress are resolving to amend the Constitution, at if we agree on the same thing, then pwede natin padala to sa COMELEC. That's my submission.
Mr. Chairman.
Minority Leader.
Mr. Chairman, can I?
Wait, Minority Leader? Would you give time?
May I just make a manifestation on the very good question
Representative Rodriguez.
thank you. On the very good issue presented by the Honorable Minority Leader. Whether we have a BICAM or we will have adoption of the Senate and the vice versa, it will never go to the President because this is an exercise of constituent power. This is not legislation. In other words, the Constituent Assembly is much higher than any official in the land. including the President. And since if this will be approved, Mr. Chairman, constituent power, we change hats. When we vote in our assembly, constituent assembly, after this approved by this preparatory committee of the whole, then we exercise that sovereign power as representatives of our, not as representatives of the people, but already having the constituent power to pass amendments or revision. So there will never be, in this endeavor, we are exercising our constituent power high above the President of the land. And this will go to the COMELEC because after all, we have already approved a budget for plebiscite. Thank you very much, Mr. Chair.
Thank you, Mr. Chair.
The chair would like to recognize first, I see Attorney Garbin raising his hand.
I was
You have
of the impression that what the minority leader was asking was the effect of the insertion of the phrase unless otherwise provided by law. Ang aking mong pagkakaintindi, ang tinatanong niya, anong epekto at kung ano ang mga susunod na gagawin to effect the needed change in that restrictive economic provision. And that's why I said, when this House approve and the Senate also approve inserting the phrase unless otherwise provided by law in that restrictive economic provision, in effect, it will become flexible. But the statement or clause to which the phrase unless otherwise provided law is attached is rendered negated or inoperative upon the happening of a condition. What is the happening of the condition? That is, by law refers to a bill passed by the legislature and signed into law. The condition then that creates an exception or operates to negate the clause to which the phrase unless otherwise provide is attached is a bill passed by Congress and signed into law by the President. But I totally agree with the majority floor leader and the chair of the Committee on Constitutional Amendments that in the exercise of the constituent power, which is the sole prerogative of Congress, we can propose anything but conclude nothing. Why? Because it is the sovereign Filipino people who will say yes to ratify the same or reject the proposal in a plebiscite called for that purpose. What we have right now is just old proposals. The one who has the ultimate say is the sovereign Filipino people.
Thank you for that, Mr. Chairman, for that
Minority Leader.
clarification. And moving forward, Mr. Chairman, granting na-approve po itong measure na ito at granting na ipasa din po ng Senado. Ang tanong ko po, pag na-aprobahan na, this RB 87 will not only go through legislation, they may also be further amended, revised, even repealed further in the future in the sense of the Filipino people, that the sense of the Filipino people may be expressed through their elected representatives in Congress. Ibig sabihin, pag nagpasa na tayo ng batas as may be enacted by law, yung batas na yan, pwede natin i-repeal, i-amend, na hindi na tayo pupunta sa taong bayan. Dahil batas na po yan. Tama po ba?
Well, that is my view. Tama po.
So, ito po yung pagkakaiba sa mga provisions na ito. Dahil sa ating konstitusyon, marami pong provisions tayo na ganun as may be provided for by law. In short, Mr. Chairman, the mode of amendments adopted by RBH 7 allows for greater flexibility in meeting future situation. Tama po ba ito? Itong ginawa.
That is correct, Mr. Chair.
At Mr. Chairman, hindi po ito, wala po sa Constitution natin yung amendments through Constitutional Convention, Constituent Assembly, or People's Initiative and Referendum. Meaning, ibang paraan po ito na wala sa Constitution. Tama po ba?
Attorney Garvin.
Hindi nakasulat, hindi nakasulat pero na in exercise of our constituent powers, not expressly written in the Constitution.
Mr.
Leader.
Speaker, if the distinguished minority leader will allow this representation to answer. And also may I remind the members of the sitting in the Committee of the Whole. We are the committee, and any member may join the discussion and improve on the discussion. And not only the questions, although directed to the resource speakers, nothing prevents any member of the House, like what happening in the regular committee, in the committee hearings, that you can interject. Any one of you can interject their position, pros and cons. They may disagree with the answer because we are functioning as a regular committee. Now, as we have said a while ago, the Constitution itself provides the authority for us to do so. Because under the Constitution, both houses of Congress, by a vote of 3/4, may propose amendment or propose a revision. And the same Constitution gives both houses of Congress the authority to enact our own rules. And we have enacted our own rules. And under our own rules, there is a section that provides when we are going to constitute as a committee of the whole, when and how can we propose through a resolution any amendment or revision to the Constitution, and what should be done, and the procedure that should be adopted. Under our rules, it is stated that once we do the amendment via the resolution, that it will be subjected in the manner that a bill is being subjected. First, second, and third reading. So we are now in that process. There is a pending resolution which referred to the Committee of the Whole, and we are now, as a committee of the whole, trying to process by interpellation, by accepting the positions of different resource speakers, and after this, like an ordinary resolution or whatever, we will have to adopt a committee report to report it out to the plenary, and the plenary will now have the chance to do a second reading and eventually leading to a third reading. So all of these are within the framework of the Constitution because, as I've said, we have adopted our rules in accordance with the power given to us by the Constitution. So I'm just saying that it is wrong to say that this is not in accordance with the Constitution. We are working within the frameworks of the Constitution.
Mr. Chairman, hindi ko po sinabi na this is not in accordance with the Constitution. Ang sinabi ko, yung sinabi ng ating majority leader na in exercise of constituent powers, kaya ginagawa po natin ito. Mr. Chairman, first time na kung ma-approve dito, first time na mag-amend tayo ng Constitution. Nasa landas po tayo na landas na tatahakin na hindi pa natin tinatahak. Ngayon pa lang na mayroon tayong seryoso na pagtalakay at pagdesisyon po tayo dito. Kaya nagtatanong po ako ng ganito dahil maraming interpretasyon po kung paano natin i-exercise yung power ng House on matter of garnering 3/4 vote of all the members so that we can propose amendments to the Constitution via Constituent Assembly. Ito po'y hindi nangyayari dahil hindi noong tinatalakay ng Senado. Kaya po tayo ay nagtatanong para maliwanagan, hindi lang tayo dito as Committee of the Whole, pero ang mga taong bayan na sa ngayon po ay nagtatanong din po sa atin kung ano itong ginagawa natin na napaka-importante dahil saligang batas ng ating mahal na bayan po ito. At any rate, Mr. Chairman, I have counted at least 11 instances in the 1987 Philippine Constitution where the phrase, I quote, unless otherwise provided or fixed by law occurs. In some, the proposed amendments in RBH 7 are not really peculiar nor strange, since they are consistent with such other occurrences in the constitutional text. Is that not correct, our Chief Justice? Can you please answer to those comments?
Yes, Your Honor, that praise as may be provided by law has been used in some other provisions, not only of the 1987 Constitution, but even in the previous constitutions. But the function of that praise, as may be provided by law, is limited. It is limited in the sense that it merely signifies that that particular provision of the Constitution is not self-executing. Kagaya po ng political dynasty. Pag tinignan nyo yung provision ng Constitution dyan, nakalagay as may be provided by law. Ang gusto sabihin no, yung provision ng sa political dynasty is not self-executing. Pero doon sa mga instances po na yun, yung as may be provided by law is not used in order to amend or revise the Constitution.
Maraming salamat po sa mga inputs ng ating resource speaker, our former Chief Justice Puno. Mr. Chairman, ano bang mangyayari? Kunyari, na-amend natin ang Constitution, na-approve natin, at hindi natin ipinasa yung batas na hindi ang Kongreso nagpasa ng batas, katulad ng sinasabi natin na anti-dynasty law, na hindi hanggang ngayon, hindi pa naipasa. Ibig sabihin, hindi ba magiging operatiba ang mga amendments na ito pag hindi nag-aksyon ang Kongreso? Tama po ba?
Dito po sa ating pinag-uusapan, iba naman yung function ng praise unless otherwise provided by law. Dito po ang function ng paggawa ng batas is to amend a particular restrictive provision of the Constitution. At yun po ang sinasabi nung iba na hindi po pwedeng gawin yan. Sinasabi nila na Congress, in the exercise of its lawmaking power, cannot amend or revise the Constitution for a very important reason. Yung gagawing batas ng Kongreso to amend or revise the Constitution will follow the usual process of lawmaking, which means it will be passed by both houses. The bill goes to the President, is approved by the President, and that is it. That's the end of the process. And yet, the end of the process is to amend or revise the Constitution. Yun po sila sabing maaari maging ang constitutional aspect. Dahil lahat ng Constitution natin, pagdating sa pagbabago ng Constitution, any change in period, change in punctuation, kailangan aprubahan ng tao. Itong batas na gagawin ng Kongreso, hindi po isasubmit yan sa Kongreso eh. Hindi sasubmit sa COMELEC, at yung COMELEC hindi sasubmit sa tao para aprubahan o disaprubahan. But what makes an amendment or revision of the Constitution valid? What makes any change or amendment or revision in the Constitution valid is the approval of the people. That is the point, Your Honor.
Mr. Chairman, my time is up. Gusto kong magpasalamat sa ating mga resource speakers sa kanilang magagandang answers para ma-clarify yung mga issues natin. At nagpapasalamat ako sa kanila, lalo na yung ibang mga congressmen and congresswomen na nagpa-participate para ma-enhance itong proceedings natin. Dahil pagdating ng araw, ito po yung titingnan ng taong bayan kung anong gusto natin. Napaka-importante po dito ang legislative intent. Kaya tayo nagkagulo sa voting jointly or separately dahil walang masyadong discussion tungkol dyan. Ngayon po ay ang panahon para itama natin ang mali. Marami pong salamat, Mr. Chairman, Madam Majority Leader.
Mr. Chairman.
Mr. Leader.
Mr. Chairman, I move that we recognize the Honorable Joel R. Chua of the 3rd District of Manila for his questions to the resource persons.
The Honorable Joel Chua, you have the floor.
Thank you, Mr. Chairman. Mr. Chairman, I would like to address my question to the Honorable Director General Balisacan of NEDA or any of his representative, if there is any.
Please proceed.
Yes, Mr.
Okay, thank you, Mr. Chairman. The phrase "unless otherwise provided by law" allows Congress to legislate 100% foreign ownership on public utility, educational institution, and advertising industry. Is this correct?
I think so.
Yes.
Yes.
Okay, thank you. Hypothetically, with a constitutional restriction on foreign ownership, how much investment are we losing? Just a ballpark.
Yusek Edilion.
Yes, Mr. Chair. Mr. Chair, we have the comparative investment stats of the Philippines and Vietnam from the period 1990 to 2000. And just to say that in 1990, Vietnam only had $243 million of investment, FDI, whereas the Philippines had 3.26 billion. And then fast forward to 2022, Philippines has received 113 thereabouts billion dollars, whereas Vietnam received 210. So meaning we are looking at a difference of about 100 billion. And this one is, a lot of this is really due to the liberalization efforts that was done by Vietnam.
So, corollary to that, how much in terms of investment or massive investment do we expect to gain? Could you please give us the breakdown sa public utility, sa educational institution, as well as in the advertising industry?
Yes, thank you, Mr. Chair. We do not yet have the computations for the public utility. We just want to mention that with respect to the liberalization of the renewable energy, for instance, we already received 800 billion. And then for our computation with respect
800 million in dollars or in peso?
pesos.
Pesos. 800 million in peso.
Okay. Oh yeah, that's just for last year because we just liberalized it. Now, with respect to education and advertising, we have some forecast numbers, estimated numbers. And for the direct impact of education, where it is just in terms of increasing the number of our foreign students, right now we have about 36,000 foreign students. So if we are able to double this, then we can expect something like $456 million in investment. And this, including the multiplier effects of the consumption of the students, etc. This will lead to a 0.2% increase in our GDP. But we would like to state as well that we think that if we lift the restrictions on education, there will be more impact on the GDP because of the greater internationalization, greater collaboration also with respect to R&D and also on innovation. On advertising, again, given the current economic structure of the Philippines, we think that liberalizing this, opening up this advertising industry would give us $390 million. But right now, there's not much in terms of multiplier of this industry. And so the impact with respect to the GDP is only a 0.06%. But we think that if we will have a bigger pool of this sector, this will actually be a magnet for our creatives as well, and also for the innovation sector. Thank you.
Thank you, Mr. Chair. Mr. Chair, maybe we can ask the resource person to submit a projection or data with respect to this investment. Pwede po ba yun?
Yes, Mr. Chair, we will
Thank you.
comply.
Another question, Mr. Chair. How about in terms of employment? How many can we generate from this investment, from the public utility, from the educational institution, as well as from the advertising industry?
Yeah, Mr. Chair, if you would allow us more time to work on the numbers with respect to employment, because the thing is, we want to attract this foreign direct investment because these are the capital-intensive foreign direct investment, and that these are the ones that would actually affect the other industries. So we have to work out the cascading effect.
Okay, maybe you can include that in the data that we asked to submit before this committee. Mr. Chair, my last question, because I read the resolution that was submitted by Congress, I noticed that in Article 14, Section 4, Paragraph 2, the word basic was included or included in educational institution. So my question is, ano po ba ang covered nitong basic? Ito po ba ay primary, secondary, o included din sa basic yung tertiary?
Yeah, Mr. Chair. As per our legal framework, basic education would pertain to primary and the secondary level.
Okay. Thank you, Mr. Chair. That concludes my question. Siguro magdadagdag na lang po ako during the second round. Thank you, Mr. Chair.
Okay. Floor leader.
Mr. Chairman, I move that we recognize the Honorable Edsel Lagman for him to put forward questions for resource persons.
The Honorable Edsel Lagman, you have the floor. Please proceed.
Thank you, Mr. Chairman. This question is addressed to any of the resource persons or even to the majority leader. If the proponents of this resolution are convinced that the sure way of attracting foreign direct investments is by liberalizing the economic provisions of the Constitution, then why are they not proposing the extent, the latitude, or ratio of foreign ownership of public utilities and other sensitive industries, rather than let it be subsumed under unless otherwise provided by law?
Mr. Chairman, may we request Mr. Calixto Toti Chiquiamco of the Foundation for Economic Freedom to answer the...
I think it should be the sponsoring congressman who will answer why that the resolution is like that. Perhaps Congressman Rufus, you can answer.
Few minutes suspension, Mr. Chair.
Hearing is suspended. Hearing is resumed.
Mr. Chairman, may we request the Honorable Ed Selagman to reiterate his question and whether he will direct it to the Honorable Stella Kimbo or the resource persons present today.
Well, I said from the start that this question is directed to any of the resource persons who are supporting this resolution on liberalizing the economic provisions in our Constitution, or it can be directed to any of the authors of the measure. I would repeat my question. If the proponents of this resolution are convinced that the sure way of attracting foreign direct investments to the Philippines is by liberalizing the economic provisions in the Constitution, then why not propose the extent, the latitude or ratio of foreign ownership of public utilities and other sensitive industries?
Prior to our honorable colleague answering, Mr. Chair, may we inquire from the resource person present who are supportive of RBH 7 if anybody is willing to answer to the query of the Honorable Lagman. The Honorable, Mr. Toti Chicampo of the Foundation for Economic Freedom is raising his hand. Mr. Chair, can he be recognized?
Yes, the chair would like to give the floor to Mr. Toti Chikiamco.
Well, the position of FEF is to outright eliminate these restrictions. So we agree with former Chief Justice Puno that we should not, instead of putting unless provided by law, outright repeal all these restrictions so that so it can be even up to 100%. Because again, there will be an immediate effect, positive effect. So secondly, there will be signaling effect to the foreign investors that we are welcoming them. And thirdly, it cannot be any more questioned on constitutional grounds, as former Chief Justice Puno has said. That is the FEF's position.
Okay. The chair would like to recognize Representative Stella Kimbo. You have the floor.
Mr. Speaker. Mr. Speaker, the purpose is to introduce flexibility. In other words, we want to remove economic policy making away from the Constitution and put it in economic legislation, which is the proper place. And we do that by introducing the phrase, unless otherwise provided by law, which means we don't want to put a specific parameter. We don't want to say 40-60 or maybe 45-55. Baka magkamali po tayo, Mr. Speaker. Kailangan natin lagyan ng unless otherwise provided by law. We let Congress determine the specific parameter. We subject it to stakeholder consultation, public hearings, plenary debates, the usual process. That's how we want economic policy making to go, Mr. Speaker.
Representative Lagman.
Mr. Chairman, unless otherwise provided by law, envisions a contingent legislation and puts both the people and the investors in suspended animation. So why don't we be more concrete and precise? If you need more studies in order to determine the exactitude or the ratio of foreign ownership, then why rush this resolution. Conduct first the studies and the consultations. Because our people will have to wait for that contingent legislation. Even the investors will have to wait. Because we will have to pass the law liberalizing the economic provisions. I don't think that should be the proper way of doing things. Moreover, Mr. Chairman, presently, the President does not participate in the amendatory process of the Constitution. But if we adopt this mode of unless otherwise provided by law, every bill will have to be referred to the President for his approval or veto. And it will short-circuit the people's ratification of the amendment because it is now only a law. This would entail many difficulties as well as problems, Mr. Speaker, Mr. Chairman. For example, you have a law saying public utilities, the foreign investor can have up to 80%. That is a bill. And once the bill is passed by both chamber and an enrolled bill is made, it will be referred to the President. The President can even veto the bill. But the people do not anymore participate because it is not referred to a referendum or a plebiscite. I think we should be able to study very well the consequences of this resolution. Let me go to another point, Mr. Chairman.
Mr. Speaker,
Okay, yes.
if I may,
Yes, Representative Kimbo, you may respond.
with due respect to the Honorable Lagman, at the moment, meron naman pong batas. For example, in the case of educational institutions, there is a current law, which is no foreign entity can come in. It's 0%. There is no uncertainty. Everybody in the world knows that there's an absolute prohibition. So if we put in the phrase unless otherwise provided by law, tayo po sa Kongreso, we can change that. So it is the change that we can study carefully in Congress. But there is an existing law while Congress can study the change. So hindi po accurate na sabihin na in suspended animation po ang tao. Kasi meron naman pong status quo, which for education is 0 until it will be changed by Congress. So yun po ang aking paglilinaw, Mr. Speaker.
Mr. Chairman,
Yes,
we
Representative
don't have to
Tuan.
say unless otherwise provided by law because there is already an existing law and Congress does not enact laws which are unrepealable or unamendable. So that is not the question. The question is, there is the purpose of liberalizing even the ownership in education. In education, I think it's 60% under the Constitution. And we are telling foreign investors that we are going to amend this. But we are not telling them how much are we going to give them. Because we will have to wait for a contingent legislation. That is a problem. How can you attract investors by asking them to wait for a contingent legislation? Now, let me go to another point. May we know whether resolution of both houses number 7 provides for adopting a fourth process or mode of amending the Constitution, which is by legislation, as underscored by the phrase, unless provided by law. We could refer this to the esteemed and Honorable Chief Justice Renato Puno.
The Honorable former Chief Justice.
Your Honor, again, let us look back at our previous constitutions. The 1935 Constitution, as well as the 1973 Constitutions. Under these two constitutions, there were only two ways of amending or revising the Constitution. Number one, by constitutional convention. Number two, by Congress exercising its constituent power. Then came the 1987 Constitution. The 87 Constitution preserved the two ways of amending or revising the Constitution. Amendment or revision by constitutional convention, amendment or revision by Congress exercising its constituent function. But the 1987 Constitution added a third mode of amending the Constitution. And this is by means of people's initiative. And so, you look at these three constitutions, especially the 1987 Constitution, there are only three principal modes of amending or revising the Constitution. One, through the Constitutional Convention. Number two, through Congress exercising its constituent function. And three, through people's initiative to amend the Constitution. Those are the three recognized ways of amending or revising the Constitution.
Thank you, Chief Justice. In other words, there are only three. And under our constitutional system, mere legislation cannot amend the Constitution because the Constitution is over and above ordinary statutes. But under this resolution, it appears that we are injecting a fourth mode, amending the Constitution by legislation, unless otherwise provided by law. Would you subscribe to such proposal?
Your Honor, precisely, I raised a red flag on this way of amending the Constitution, amendment by means of a law. But having said that, I stress that I'm not passing a hard judgment on this model that is being adopted. I'm just saying that this RH number 7 may be constitutionally suspect if we retain that phrase unless provided by law. And precisely in order to drive away that fear, I suggested that we just repeal outright these three restrictive provisions. If we repeal these three restrictive provisions, that will release the power of Congress to pass the necessary laws in order to liberalize the so-called restrictive provisions. That was my humble suggestion, Your Honor.
Yes, Mr. Chief Justice, I heard that loud and clear. In the event that we repeal this constitutional provision, which we call the nationalistic provisions in the Constitution, that would have to be through the process of a Constituent Assembly and also ratified or rejected by the people in an obligatory referendum or plebiscite. Is that correct?
Your Honor, if Congress would meet as a Constituent Assembly, the power to amend or revise the Constitution has always been granted by the 1935 Constitution, granted by the 73 Constitution, and granted by the 87 Constitution. There is no question about the power of Congress to amend or revise the Constitution in the exercise of its constituent power.
Okay. Consequently, if this resolution of both houses number 7, which is a replica of resolution of both houses number 6 in the Senate, would be approved, then it would pass through a Constituent Assembly and ultimately to be ratified by the people. So we are following the constitutional process. Thank you, Mr. Chief Justice, for your inputs.
That is the school of thought that is championed by Father Bernas. That this provision of the Constitution now should be interpreted as a grant of power to Congress as a Constituent Assembly to amend or revise the Constitution. But his further view is that with respect to the exercise of this power in its details, meaning how the power will be exercised, whether the meeting will be joint or separate, whether the voting will be joint or separate, depends on the rules of both houses that they will be agreeing upon. That is the view of Bernas. And that is not the classic traditional formulation used in the 1935 Constitution and in the 1973 Constitution on how Congress, acting as a Constituent Assembly, should amend or revise the Constitution. You look at the 1935 Constitution, Your Honor. It does not only say that Congress has the power to amend or revise the Constitution as a Constituent Assembly. It does not stop there. The 1935 Constitution on that particular issue particularizes also how the power will be exercised. It decides the details themselves. The provision in the 35 Constitution, and that is the traditional formulation, it specifies that the meeting shall be joint, that the voting shall be separate. In other words, both the grant of power and how the power will be exercised in its details are all specified in that particular provision. That is the difference.
I don't subscribe to the Bernas proposition because, in the first place, you have said that it is not anchored on any deliberation in the Constitutional Commission. What I am saying is that if this resolution of both houses is approved and by the House and similarly approved by the Senate, I think this should be formalized in a Constituent Assembly as a proposal to amend the Constitution and submitted to the people in a referendum. That is all I am saying. And whether the voting would be separate or joint, I think this question will have to be elevated to the Supreme Court as the final arbiter of constitutional issues. Thank you, Mr. Chairman. Thank you, Chief Justice.
Thank you, Representative Lagman. Floor Leader.
Mr. Chairman, I move that we suspend consideration of resolution of both houses number 7.
There's a motion to suspend consideration of resolution of both houses number 7. Any objection?
Mr. Chairman, before you rule, may I just
Representative
want,
Palma.
point of clarification. Is the Honorable Chief Justice be available tomorrow?
Yeah, Mr. Chairman, may the Honorable Palma reiterate his question? If the resource person will be back tomorrow?
Yes.
Yes, Mr. Chair, they will be back tomorrow. They have been advised, and we will reiterate it in a while.
At 1 o'clock, Mr. Chair?
Yes, Mr. Chair.
Okay. Thank you. Thank you.
So, Mr. Chairman,
Mr. Chairman,
Favor that, Representative Rodriguez.
yes, it will be difficult, Mr. Chairman, distinguished colleagues, and our majority leader, to ask our resource persons to come back tomorrow. It's only 6:48 p.m. We would like to therefore just continue and finish those in the list because then we have a different set of resource persons tomorrow.
Mr. Chairman.
So I would like to, let us have this. They are already here and so we
Before that,
ask for consideration so that we can continue such a very important committee constituted as a whole house.
Hearing
Mr.
is
Chairman.
suspended for a minute. Tanong mo muna kung... Hearing is resumed.
Mr. Chairman, prior to putting forward our favorite motion, the Majority Leader would like to request and remind the resource person to be back tomorrow by 1 o'clock in the afternoon. And for the information also of all members of this august body, the continuation of the questions and the interpellation to our resource persons will be continued tomorrow. With that, Mr. Chair, I move that we adjourn this hearing, we suspend the hearing of the Committee of the Whole until 1 o'clock tomorrow.
Yes, Mr. Chair.
Representative Rosas.
Yes, Mr. Chair. Will there be, point of inquiry lang, Mr. Chair, will there be any other resource persons pertaining to the general principles tomorrow, Mr. Chair? Will we add a set of other resource persons, Mr. Chair?
If they will be present, Mr. Chair. So far, invitations have all been sent, and there were also several follow-ups by the committee. And those who declined will also be not available tomorrow. But if our honorable colleague, the Honorable Arlene Brosas, has recommended resource persons, the Secretariat is very much open.
Yes, please, Mr. Chair. We have a set of resource persons that we would like to be invited, Mr. Chair, and we will course it through with them. Thank you, Mr. Chair. So they will be able to speak tomorrow.
Unless they will not be resource persons, Mr. Chair, of the three
Yes, we'll check.
specific
The
topics. We will.
Chair would like to direct our Secretariat to get the list, and we'll invite them tomorrow. Okay. Noted, Mr. Chair.
Thank you, Mr. Chair. Thank you.
Your leader.
Mr. Chairman, allow me to reiterate my motion to suspend the hearing of the Committee of the Whole until 1 o'clock tomorrow afternoon.
This hearing of the Committee of the Whole is suspended until 1 o'clock tomorrow, February 27,
2024.
2024. Na? Ha? Hello. The meeting of the Committee of the Whole is hereby resumed. Floor leader.
May we now
Floor leader.
no mic.
Meron na.